You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A defendant in a criminal case may take the stand and testify, and be examined and cross-examined as any other witness. However, no defendant has to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding the credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. This defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or intentionally causes some other person to commit the crime under such circumstances that the other person is not guilty of any crime either in fact or because of legal incapacity. Any party to a crime who did not directly commit the crime may be prosecuted for the commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crimes charged in the indictment were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of, and was not a conspirator in, the alleged offenses, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes charged in the indictment were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict the defendant. A jury is not authorized to find a person who was merely present at the scene of a commission of a crime at the time of its perpetration guilty of, consent in, and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, that the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct, circumstantial evidence, or both. The defendant is charged in count 1 with murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be a significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or killing and it moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The defendant is charged in counts 2 and 3 with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and criminal damage to property in the first degree are both felonies, which I will define for you shortly. You may find the defendant guilty of felony murder as alleged in count 2 if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. You may find the defendant guilty of felony murder as alleged in count 3 if you believe that he caused the death of another person by committing the felony of criminal damage to property in the first degree, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. The defendant is charged in counts 4, 5, 6, 13, and 14 with aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. The defendant is charged in count 7 with criminal damage to property in the first degree. For criminal damage to property in the first degree, the state must prove that the defendant, knowingly and without authority, interfered with any property so as to endanger human life. The defendant is charged in counts 8 and 15 with possession of a firearm during the commission of a felony. For possession of a firearm during the commission of a felony, the state must prove that the defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is a crime against or involving another person. Murder, felony murder, aggravated assault with a deadly weapon, and criminal damage to property in the first degree are referenced in count 8. Each of those offenses are felonies which have been and have been defined in this charge. Aggravated assault with a deadly weapon is referenced in count 15. That offense is a felony and has been defined in this charge. For purposes of this offense, a firearm includes any handgun or rifle. The defendant is charged in counts 9, 10, 11, 12, 17, 18, 19, and 20 with the offense of violation of the Street Gang Terrorism and Prevention Act, also referred to as the Gang Act. For a violation of Subpart A of the Gang Act as alleged in counts 9 and 17, the state must prove that there is a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant participated in criminal gang activity, and that there was a nexus between the crime that was committed and the gang, i.e., that the crime was committed to further the interests of the gang. For violation of subsection B of the Gang Act as alleged in counts 10 and 18, the state must prove that there is a criminal street gang, and that the defendant is associated with that criminal street gang, that the defendant participated in criminal gang activity, and that the defendant committed criminal street gang activity with the intent to maintain or increase his status within the criminal street gang. For violation of subsection E of the Gang Act as alleged in counts 11, 12, 19, and 20, the state must prove that there is a criminal street gang, that the defendant encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate of that criminal street gang. For purposes of the Gang Act, the term participate can, but does not have to be defined as, to take part in something and or to share in something. Criminal street gang means any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal gang activity. The term criminal street gang shall not include 3 or more persons associated in fact, whether formal or informal, who are not engaged in criminal gang activity. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including, but not limited to, common activities, customs, or behaviors. Whether a criminal street gang exists in this case is for you, the jury, to decide. Criminal gang activity means, among other things not relevant to this case, the commission, attempted commission, conspiracy to commit, or solicitation, coercion, or intimidation of another person to commit any criminal offense that involves violence, possession of a weapon, or use of a weapon. For purposes of the counts charging a violation of the Gang Act, murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property, and possession of a firearm during the commission of a felony constitute criminal gang activity. The commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal gang may be considered by you to determine whether the state has proven beyond a reasonable doubt the existence of the criminal street gang and criminal gang activity. Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to an inference of the existence of a conspiracy. A conspiracy is an agreement between 2 or more persons to do an unlawful act, and the existence of a conspiracy may be established by proof of acts and conduct, as well as by proof of an express agreement. When persons associate themselves in an unlawful enterprise, any act done by the party to the conspiracy to further the unlawful enterprise is considered to be the act of all the co-conspirators. However, each person is responsible for the acts of others only insofar as such acts are naturally or necessarily done to further the conspiracy. Whether or not a conspiracy existed in this case is a matter solely for you to determine. The verdict form lists all of the counts and offenses you will be considering. You will consider each offense listed. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did on or about the date alleged commit an offense or offenses charged as alleged, you would be authorized to find the defendant guilty of such offense or offenses. In that event, the form of your verdict for such offense or offenses would be, we, the jury, find the defendant guilty, and you should place an X or a check mark on the blank next to the word guilty for any such offense or offenses. If you do not believe that the defendant is guilty of an offense or offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant on that count or those counts. In that event, the form of your verdict would be, we, the jury, find the defendant not guilty, and you should place an X or check mark on the blank next to the word not guilty for any such offense or offenses. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. There are 2 alternate jurors, and we can only allow 12 to deliberate the case. The deputies will show the alternate jurors to a separate location. That's jurors 33 and 35. You may now retire to the jury room. You may elect a foreperson, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in the case. Any jury communication to the court must be in writing, signed by the foreperson, so that means questions. Now, I know that you've requested to actually perform your deliberations in a different location, and that's fine, but if you want to see evidence that you don't receive in the back, which will be much of the evidence, you're going to have to come back down here to see it. So just so you know that, in open court. If you have any questions or you want to request evidence, you just send us a note and have your foreperson sign it. All right, will you go ahead and step out?
All right, to the jury.
Okay. Do you guys want to take a look at whether you agree on what goes back?
Yes, Your Honor, but before we go forward, on behalf of Mr. Conley, we'd like to renew all objections.
Okay. And just let me know if I need to break a tie on something. Otherwise, if you agree, it'll go back.